Welcome to the participants of the All India Bar Examination, 17th Court 2023, and today is the Indian Evidence Act 1872 multiple choice questions. Yes, be ready. I am sure that you could see my screen. Am I right?
Yes, sir.
Good. First question. Admission. Choose the correct option. 1. By party to proceeding or his agent. 2. By suitor in representative conduct and character. 3. By party interested in subject matter. 4. By person from whom interest derived. So options: A 1 plus 2, B 1 plus 2 plus 3, C 1 plus 3 plus 4, D 1 plus 2 plus 3 plus 4.
C is right answer, sir.
Why?
1 plus 3 plus 4.
Why the C is the right answer? Reason you have to show. See, A by party to the proceeding or his agent is very much right. By suitor in representative conduct, I added conduct and character. There is no conduct. That you have to say. Representative, no conduct and character. That is only character. Representative character. So other 3, 4 are right. Hence the right answer is C is the right answer. The second question. Anyone can unmute and read the second question?
No.
Cases in which a statement of relevant fact by a person who is dead or cannot be found, etc., is relevant. Option A 1. When it relates to the cause of action. Option 2. Or is made in course of business. Option 3. Or against the interest of the maker. Option 4. Or gives an opinion as to be public rights or customs or matters general interest.
Option A 1 plus 2, option B 2 plus 3 plus 4, option C 1 plus 3 plus 4, option D 1 plus 2 plus 3 plus 4. Shoot.
Sir, B is right answer, sir. 2 plus 3 plus 4.
Wrong. Hey Nandini, shoot. When you don't speak, you mute it. When you speak, we can unmute. Anyone can shoot.
Sir, D is right answer, sir. 1 plus 2 plus 3 plus 4.
Can you tell me the reason? What is wrong in the 1? What is wrong in the 1?
Cause of by action.
Is not cause of action. It's the cause of death. It is not cause of action. It's the cause of death. See the feedback. So 1 is wrong. And the right answer is, please mute. Nandini, mute. Hey Venkatreddy, you also mute. When you give the answer at the time, we can unmute. Nandini is not muting. I will mute her. Yes, now I muted her. So next question. In the second question we dealt it, now the third question. Cases in which a statement of relevant fact by a person who is dead or cannot be found, etc., is irrelevant. Number 1, are related to the existence of relationship. 2, or is made in a will or deed relating to family affairs. 3, are in a document relating to the transaction mentioned in the section 13, clause A. 4 or is made by the several persons and express feeling relevant to the matters in question, then options are A 1 plus 2, B 1 plus 2 plus 3, C 1 plus 3 plus 4, D 1 plus 2 plus 3 plus 4. So among these four options, which is the right option?
Sir, option B 1 plus 2 plus 3.
Wrong.
Option C is right answer, sir. 3
Wrong.
plus 3 plus 4.
There is
It
no
is right answer,
mistake at all, as it is. So the right answer is
D is right answer. 1 plus 2
B
plus
is
3
the
plus
right
4.
answer. 1 plus 2 plus 3 plus 4 is the right answer. I did not change anything. Everything is the normal. Now let us see the next question. That is the fourth question. Find out which is a mismatch among the four options. I say mismatch. A. Section 35. Relevancy of entry in public record made in the performance of duty. Section 36. Relevancy of the statement in maps, charts, and plans. Option C. Section 37. Relevancy of entries in books of account when relevant. Option D. Section 38. Relevancy of statement as to any law contained in the law books. Which is the mismatch among the ABCD?
C, sir. Section 37.
C is the mismatch. Why is C is mismatch? Can you tell me? It is a
Because-
different section. It is roughly 32 or 33. I put it there at the 37. Relevancy of entries in books and accounts when relevant is not the proper. Hence, the right answer for the mismatch is fourth, C. Yeah, which option is the correct option? Here, fifth question. Which option is the correct option? Number 1, section 47, capital A, option as to the e-signature when relevant, and here B, 48, opinion as to the, of course here 1 I have forgotten, 2, 48 section, opinion as to the existence of the right or customs when relevant, and 3, section 49, opinions as to the usages, tenets, etc. when relevant. Then the option 4, section 50, opinions on relationship when relevant. Here I have given the options. A, 1 plus 2 plus 4, B, 1 plus 3 plus 4, C, 1, 2 plus 3 plus 4, D, 1 plus 2 plus 4. Which is the correct option? Shoot.
Option C, sir. 2, 3, 4.
Option C is the right answer. 2, 3, 4 is the right answer. The reason is there is no e-signature. It is a digital signature. It is not the e-signature. It is a digital signature. Is it clear?
Yes.
Good.
Yes, sir.
Then sixth question. Anyone can unmute and read the sixth question? Anyone can unmute and read the sixth question?
In which chapter there is only one section of the Indian Evidence Act 1872? A. Chapter 8, Chapter 9, Chapter 10, or Chapter 11?
There is only one section of the Indian Evidence Act. In which chapter?
11th chapter is only one section.
It's the 11th chapter is only one section. Feedback C.
11th, sir. Yes, sir.
Chapter 11th of improper admission and rejection of evidence. Can you tell me what is the section?
167, sir.
I appreciate. Yes, it's the last section. 167 is the chapter 11. That is the Right answer. Now the seventh question is, no new trial for the improper admission or rejection of evidence envisaged in which dash of the Indian Evidence Act 1872. Option A, Section 164. Option B, Section 165. Option C, Section 166. Option D, Section 167. Shoot.
167, sir.
It is 167 is the right answer. So under section 167, no trial for improper admission or rejection of evidence envisaged in which means section 167 of the Indian Evidence Act 1872. Eighth question. Anyone can unmute and read? Anyone?
How many sections and how many sections dash and how many schedules dash are repealed in the Indian Evidence Act 1872?
Option A 00, option B 11, option C 21, option D 12. Shoot.
Sir, option C, 2-1.
Wrong. The right answer is 1-1. B is the right answer. 1-1. Now, supplementary question. Which section is repealed and which schedule is repealed? Supplementary
Schedule
question.
2 is repealed, sir.
Repeat the answer.
Schedule 2 is repealed, sir.
There is no schedule 2. When I say answer is 1-1, means schedule is 1 and section, which section?
Section 2.
Section 2 is removed. Section 2 schedule is removed. I mean repealed, not removed, repealed. Is it clear?
Yes, sir.
Good. Then the ninth question. The Information Technology IT Act 2000 was amended to allow for the admissibility of the digital evidence. An amendment to the dash provides the legislative framework for transaction in the electronic world. Which acts are amended because of the Information Technology 2000? A. Indian Evidence Act 1872. B. The Indian Penal Code of 1860. C. The Indian Contract Act of 1872. D. The Bankers Book Evidence Act of 1891.
B is right answer, sir. The Indian Penal Code 1860.
See here, I should ask the question, which option is wrong option? Because I have not given the other things here.
Option D is wrong, sir.
Which option is the wrong? Wrong. Which option is the wrong option? Which option is the wrong option?
D is wrong option, sir.
Yes?
D, sir.
D is wrong option.
WRONG. Which option is the wrong option? The right answer is C. There is no Indian Contract Act of 1872. But other three are amended. Indian Evidence Act is amended. The Indian Penal Code is amended. The Bankers Book Evidence Act is amended. But not the Indian Contract Act. I fabricated. 10th question. The Act, the Indian Evidence Act, identified as Act number 1 of 1872 and called the Indian Evidence Act of 1872, has 11 chapters 167 sections and came into force 1st September 1872. At the time, India was a part of dash. In the dash, A, British Raj, B, Imperial Empire, C, Royal Empire, D, British Empire.
British Empire, sir. Option D.
Option D is the right answer. It is the British Empire, not British Raj, not Imperial Empire, not Royal Empire. So here oral evidence and documentary evidence and primary evidence, and of course these are the type of the evidences. Okay, now, so 10th question is over. 11th question. How many dash type of evidence under the Indian Evidence Act? A, 8, B, 9, C, 10, D, 11. Shoot. How many dash type of evidence under the Indian Evidence Act? Please take the screenshot when the maximum numbers are present. The answer is 10, means C. There are 10 types of evidences under the Indian Evidence Act. And the 12th question. The law of evidence which branch out of the law of the procedure, I quote, means through argument to prove or disprove any matter of fact, the truth of which is submitted to judicial investigation, and quote, according to, who said? A, Sir Blackstone, B, Sir Taylor, C, Sir Stephen, D, Section 3 of Indian Evidence Act. Regarding the evidence, the quotation, who said? Yes?
C is right answer, sir. Sir Stephen.
Wrong. WRONG. Second option.
Option B, sir.
Option B is the right answer. Sir Taylor. According to Sir Taylor, the evidence is branch of the law of procedure, and quotation is given by the Sir Taylor. Now the 13th question. Which one is odd man out? Means something entirely different from others. A, oral evidence, B, written evidence, C, primary evidence, D, documentary evidence.
B is you, sir. Written
Yes.
Sir,
evidence.
the written evidence.
Written evidence, which is odd man out. Even the 10 evidences, it is not there. And the 14th question. Which one is odd man out? Options. A, factual evidence, B, hearsay evidence, C, real evidence, D, judicial evidence. Which is odd man out, which is not there in the evidence list?
Odd man out. A is you.
Sir, C, real evidence.
What is that?
C, real evidence.
No, it is there.
A is correct, sir. Factual evidence.
Factual evidence is odd man out. There is no factual evidence. There is the real evidence is there. Hearsay evidence is there. Judicial evidence is there. But not factual evidence. And regarding 15th question, which option is true option? I said true option. Number 1, direct evidence. Number 2, indirect evidence. Number 3, non-judicial evidence. Number 3, circumstantial evidence. A. 1 plus 2 plus 3. B. 2 plus 3 plus 4. C. 1 plus 3 plus 4. D. 1 plus 2 plus 3 plus 4.
A is right answer, sir. 1 plus 2 plus 3.
WRONG. Just use your brain. Logic.
Sir, option D.
Yes.
Option D, 1 plus 2 plus 3 plus 4.
Option D is the right answer. All are correct. I did not change anything. There is a direct evidence is there. There is indirect evidence is there. Non-judicial evidence is there. Circumstantial evidence is there. I did not change anything. So all are correct. Means all options are correct. That is the 15th question. 16th question. The word evidence has derived from the Latin expression evidence evidere, which means the state of evidence. Number 1, being plain. Number 2, seeming. Number 3, apparent. Number 4, notorious. Here the blank. So there are 1, 2, 3, 4 options. The statements I have given. Then A, 1 plus 2 plus 3. B, 2 plus 3 plus 4. C, 3 plus 4. D, 1 plus 3 plus 4. Which is the right option? The state of being, they give the other wordings, but one option is not there.
Sir, 1 plus 2 plus 3. A.
Wrong.
Option D, sir. 1, 3, 4.
Wrong.
Option C, sir.
2 plus 3 plus 4.
No. 1 plus 3 plus 4 is the right answer. D is the right answer. Why? There is no seeming. There is a state of evidence being plain, apparent, notorious. There is no seeming. So, the evidence may be plain or apparent and notorious. These are the words are there. But I fabricated seeming. And hence the right answer is 1 plus 3 plus 4. Is it clear? Say yes.
Yes, sir.
17th question.
పాస్ అయినా కూడా మళ్ళీ ఒక ఎగ్జామ్ ఉంటుంది
అయ్యా మాట్లాడాను ఇంటికాడ మొత్తం మాట్లాడతాను వినపడతాను
సిక్షన్ దాటినంటే మళ్ళీ లేదు
కన్నయ్య ఎక్క కన్నయ్య ఇంటికాడ మొత్తం మాట్లాడని నాకు వినపడుతున్నాయి మ్యూట్ కన్నయ్య నేనే మూడు చెప్తా రైట్ నౌ ఐ మ్యూటెడ్ కన్నయ్య. Okay, next 17th question. Dash permits the witness to present oral evidence of statements made by any other individuals about the contents of a document if such statements are itself relevant fact. Option A, section 142. Option B, section 143. Option C, section 144. Option D, section 145. Shoot, which is the correct section?
144, sir. Option C.
Option C is the right answer. It is the section 144 permits a witness to present oral evidence of statement made by any other individual about the contents of a document if such a statement are in itself relevant fact. And 18th question. A landmark case is a good case. A landmark case is a court case that is studied because it has dash and legal dash. It has dash and legal dash. Two dashes are there. A, significant and historical. B, historical and worth. C, historic and significance. D, historical and significance.
Option C, sir.
Read.
Historical and significance.
Historical and what?
Significance.
Wrong.
Sir, C is
Option
right
B,
answer,
sir.
sir. Historical
See, I told
significance.
you, no, a landmark case is a court case that is studied because it has a dash and legal dash.
Sir, option C, historic and significance.
WRONG.
Option B, sir.
Option D is the correct answer. It is a historical and legal significance. That is the answer for today's questions which I made. Total 18. So, I don't know how much time is left because it is 7:12. Yet we started the 9 o'clock 42 means still 3 minutes are there. Of course, 9:10 we started. So 10 means still we do have 13 minutes in our hand. So now why I have given this thing, I prepared entirely the new case, new items here, not the old one which is already made. So if you see the Law of Evidence Act, Indian Law of Evidence Act, Indian Law Evidence Contract, Indian APC Landmark, Law of Evidence, MCQ. Oh, where is this gone? Evidence, Bear Act. Law of Evidence, Landmark, Law of Evidence, MCQ, Limitation. It's not here. I already put here somewhere. Okay, now I can make it out. I can download it. No matter. Law of Evidence Act PDF 1872. Already I downloaded, but I don't know in which place that I kept it here. Yes, Law of Evidence 1872, Act number.
1, sir.
I appreciate. No, this is 19, it is wrong act. This is right act. This is also wrong. Why say chapter 1? No, there is no chapter. Things are there. I already downloaded that thing. Constitution, CPC, Law of Evidence, Indian Contract Act, IPC, Limitation Act. Where I kept it? The Law of Evidence 1872. 1872 Bear Act. This is a different. Yeah, you can see repeal 3. Yes, the Indian Evidence Act of 1872 Arrangement, Part 1, Relevancy of the Facts, Chapter 1. So here they may try to ask, Section 2 is repealed, I told you, no. And Schedule 1, only one schedule is there which is repealed. Otherwise, other things are not repealed at all. So they may ask you, proved, disproved, not proved. Proved, disproved, not proved, and they will match the following, and they can keep it. Match the following, and they may ask. Means probability would be there to ask. And they also ask the chapter 2, what it deals. Chapter 3, what it deals. Chapter 4, what it deals. Chapter 5, what it deals. And at one side, chapter 2, 3, 4, 5, another side, its explanation, means subject of the chapter. And they will make the jumble order at the part B and ask you to match the following. Did you get my point? Match the following. They can make it. See, today I asked the question from here. Have you noticed? Today I asked the question, admission. Have you noticed?
Yes, sir.
What I added, what I deleted here. Can you tell me? I want to check your memory. In this one, what I added, what I deleted. Either it's a pass on, I will give the answer.
Vasan, sir.
See, I told you, no, a suitor in representative, conduct and character. I added conduct and character. Here, character is there. I told you also that is wrong because there is only character is there. By added conduct and, but you could not make it out. See, I have taken from this place when I was referring. And here also, can you tell me? I have taken from this place. Can you tell me what I have taken from this place?
Yes, sir. You wrote cause of action instead of cause of death.
I wrote cause of action. I removed the death. So why I am showing this one? They can frame any type, anywhere, from any corner. They want to test you whether you have seen the Law of Evidence 1872 or not. So they can mold it. Either they can ask the sections or they can give the statement and they can make it wrong. Which is the wrong statement? See, I removed the death, I made the cause of action. That means I framed the question from here. Are you following me? I am giving you that how I frame the questions. It depends upon sequence. It depends upon, see, here also I made opinion, opinion, opinion. Is it not? I think I have taken. No, this thing I have not taken. Opinion I have not taken. Because there all the opinions are there, but relevancy I have taken. See, here I have taken. Relevancy of the judgment, relevancy of the other thing mentioned. Something relevancy also I have taken. So why I am giving is, they give the chapter 4 and oral evidence. Suppose if they ask you, what is the section estoppel?
1152, 117, sir.
Yes,
Indian
you are
Survey Act
right. You are
1872.
right. Because it started. What is burden of proof then?
1012, 110, sir.
Yes, they can ask you that like that also. See, chapter 8 is estoppel. So 115 estoppel, 116 estoppel of the tenants and the license of a person in possession, and 117 estoppel of the acceptor of the bill of exchange, bailey or license. So these are the things which may. So from any point of view, they can raise the question and see they can frame the questions. So today I try to make by using the different techniques. But if you want to use the different techniques, you have to explore it. So one more question you can. I thought of framing from here also. Examination in chief, cross-examination, re-examination, order of examination. So one side I give all the examinations, in another side I'll give its explanation or its sections. Then I say match the following. Or I make the wrong option there. Then I say mismatch. Which one is the wrong mismatch? I mean wrong statement there. So that way also we can ask the questions. And I can ask also what is the leading question? See, this is also important. Can you tell me supplementary question? What is the leading question? Anyone? Participants, are you there?
Vasan, sir.
A leading question is such a question where it is having its own answer. Have you not seen over there, isn't it? That means
Yes, sir.
You are giving him the answer. Have you not seen it? Isn't it? He say yes. Not seen. When not seen, how could we are a witness? Are you following me?
Yes,
Yes,
sir.
sir. Yes.
So that is the leading question where you can make. So then indecent, scandalous questions, indecent questions. What is indecent question? And scandalous questions. So 151 also generally they try to ask it. And there are many cases also. And I am not discussing the today cases, no. Tomorrow I will discuss cases. Tomorrow I will discuss the amendments. And tomorrow I will discuss the match, the sections and cases. I'll mention all the sections at one side and the cases at the right hand side. And I will say match the following. Which one is the matching to the section? So such a nature of the questions I am going to ask. Plus I will make the statements 1, 2, 3, 4. And I will ask you at one statement, it is wrong statement. So I can pick it from either the decision or from the act. In the decisions also, there are certain points they have given. I can take from that point also, I can frame the question. And some of the decisions, they may ask also, who is the judge? Because I saw the question paper, they asked the judge name. So at that instant, one should be very much careful. But only controversial issues case they will ask. Or the landmark judgment case they will ask. Of course, we cannot remember the judge's name, but once you read it, at least in our memory it is there. But when it appears, then naturally we will click it, the right answer. Because you have passed through it and in your memory it is caught. It is saved over there. And hence you can easily shoot it, even though you have read only once also. Because it is already feeded into your computer, in your brain. Yes, what is refreshing memory? 159. Refreshing memory. Because the case happened so many back. And we don't know what we wrote and what we signed. Because we did not remember. At the time, we go for the refreshing memory. Means the thing which you signed it, now it will be given back to you, you can read it. Am I right?
Sir.
Yes.
Yes, sir.
Yeah, that is the refreshing memory to make it out. So I told you now the schedule repealed. Only repealed is the 2 times used over there. Number 1 in the schedule. Number 2 in the section 2. And the last section is the 167, which is there in the 11th chapter. And I framed by this one. Because I checked all that. Everywhere there are not less than 1. All more than 2, more than 1. I found only 1 chapter. I found 1 section. And hence I prayed. So this is the mode I will apply it. This is the method I will apply it. This is the thinking I will apply it. This is the way I will apply it. So you can shoot it in any angle, but see that student should have to give the correct answer. So I am shooting in the different angle. I am framing the question in different angle so that you cannot miss, even though you don't know the answer, but you use your application, you use your mind, and I am sure that you definitely will shoot it. Today, you might have shooted 2 or 3, but I asked that, what is the reason? What is the logic? Where is I have committed wrong? What I added? What I deleted? But you failed to give the answer. But you shooted it in right way. How? Because I trained your brain in such a way. Is it clear?
Yes, sir.
So we are making the, see, sometimes they will ask like that 85A, 85B, 85C. So they can trace they can ask the question from by like this also. And they will make the jumbled order. They start from 85 and they end with the 85C. Because they will make it out and they will mismatch it from one to one another thing they will put it. So there is a good source to for the mismatch or the good source to the even match the following. Because it is also 80, 85, 85 capital A, 85 capital B, 85 capital C. It is there, the four are there. So it is very easy to make you to confuse which one comes in what. So this is the way that we can make the questions for today's. But now I don't know what the time is. I think the time is up because 9:57. Okay, I started the 9:10. Still 3 minutes are there. Is anything that you would like to ask? Ramesh Babu is waiting in the lobby. Ramesh Babu, you are welcome. Do you want to ask anything? Anyone has taken the screenshot when the maximum members are there? At least post me so that we do have the record whether the participants are decreasing or participants are increasing.
9 members are there, sir.
No, I saw one time 10 members was there. When I was just looking at it, I found 10 members are there, but now it's the 9 members. So with this, I would like to stop today class and we will meet again tomorrow at the exact time, 9:10 of the India time. And I'll come with I told you already that I come with the cases, I come with the section and cases, I come with the amendments, different amendments, when they made it and what they brought the changes. So in this way that we will cover in the tomorrow class. So with this, I would like to wind up my today class. Jai Hind. Jai Hind.